Everybody. I am Aishwary Narayan and I am currently working as an intern at ubAdvocate and I am a student of Faculty of Law, Banaras Hindu University. I am making this video to discuss on the topic rights of children born out of live-in relationship. As there is no explicit statute governing the concept of live-in relationship, the law governing the rights of those children are still ambiguous. In a right-based world where the rights of children are at the top of every legislator's priority, the necessity to determine these rights are very crucial. The first and the foremost right of children born out of these relationships is the right to legitimacy. We would discuss the Supreme Court rulings in this regard. In the case of SPS Balasubramaniam versus Trutayan, the HC has held that if a man and a woman are living under the same roof for a quiet period of time, they will be presumed to be husband and wife under Section 114 of the Indian Evidence Act. And the very important point to be noted in this judgment is that the children born out of these relationships will not be considered illegitimate. This is the very first and the landmark case in which Supreme Court has considered upon this topic of very important issue wherein it has legitimated the children born out of live-in relationship. Court used Article 39 Clause F of the Indian Constitution to determine the rights of these children. This article lays down the responsibility on the state to provide children with adequate facilities so that they can develop in a normal manner and to safeguard their interest. Court used Article 39 Clause F. In further cases like Tulsi versus D, Supreme Court has held that children born out of such relationship will not be considered illegitimate. The crucial condition for a child to be treated as legitimate is that the parents should have lived under one roof and cohabited for at least a period of 1 year. The main point in this judgment is that the Supreme Court focused on the topic that the relationship should not be a walk-in and walk-out relationship. The Supreme Court has focused on this topic and supported this interpretation of law so that no child should be punished for no fault of his own. The second and the foremost right which we are talking about is the property rights. The Supreme Court in Vidyadhari versus Sukrana Bai granted inheritance right to these children and granted them legal status. In one such another case of Bharat Mata versus R. Vijay Ranganathan, Supreme Court of India had held that the children born out of such relationship may be allowed to succeed in the parents' property if any, and thus given legal legitimacy. SC also focused on the topic that the discrimination of children born out of live-in relationship and marital relationship is a clear-cut violation of Article 14 of the Constitution, which guarantees equality before the law. While Section 16 of the Hindu Marriage Act 1955 offers legitimacy to these children, their rights to ancestral property and maintenance is still uncertain and vary from case to case. This is a clear-cut violation of Article 39 Clause F as we have talked earlier. Therefore, in conclusion, I would like to say that children born out of such relationship, even though not considered fully legitimate, would be entitled to all the same rights as the children born out of normal relationship. Thank you.